Good morning.
Mr. Stern?
Good morning. This is an appeal from a conviction for rape of a child, defendant's 15-year-old niece, allegedly committed in August of 2007 in the Polk family home in Dover. Molly, her pseudonym, first remembered and reported the abuse when, according to her, it popped into her mind 6 months later during a school discussion of sexual abuse.
And now help me with regard to that. Was there any, apart from that testimony, was there ever any explanation as to why she had not reported it before?
Not really. She testified that she was embarrassed or upset for her mother. She said that this was her mother's brother, and she felt uncomfortable with the whole thing.
Okay, so this is not a situation comparable to amnesia. She didn't say, I forgot, and then suddenly I remembered.
Well, she said that she did not recall it during that period of time and that she didn't think about it. But she didn't.
Well, those are two different things.
Yeah, well, that's true, but she said both. And I think the jury could infer that she didn't. She certainly didn't have it in her mind during that period of time. Let me put it that way.
Mr. Stern, you know that the district attorney takes the position that, in fact, Molly didn't have memory problems. That seems to be the thrust of why none of this testimony should have come in, according to the district attorney. What are the memory problems you say she did have, or she did display in one form or another, that would warrant any of this evidence coming in?
First of all, as to what we refer to as the bed rape, her current recollection, or at least her recollection at the time of trial, that she had been raped by an uncle in a bed from behind.
And that was not the first time she remembered it, though.
That's right. She testified that this happened sometime when she was 5 or 6 years old, that the memory then disappeared, that she recovered that memory when she was in the 7th or 8th grade, and then she didn't remember it again, and that she didn't remember it at the time she was allegedly being raped by this defendant, and she didn't remember it at the time that she was being questioned by, in the what we call here the sane interview, and that she did not recover that memory until preparation for trial, when the assistant district attorney and the investigating officer went out to Minnesota to interview her. So there was that. Secondly, in her original sane interview, she testified that the entire abuse episode really took place on 2 nights. And the first night
In the
was
one in Dover. The one
in Dover. In Dover. And first she told in some detail about how the defendant started to abuse her on Friday night. This was in front of his daughter, Maggie, in the same television room, that after a while he let her go to bed. And then it continued on the following night, which is the night in which he raped her. When it came to the trial preparation, she completely no longer remembered anything about that first night.
And the district attorney so informed you?
That's right, right. In addition, there was evidence that she had, as a younger child in her birth family, reported to her birth mother that she had been abused by another uncle in a bath. And the birth mother said that as a result of that, she was fearful of taking baths after that. She no longer regarded any such incident. She no longer remembered telling about this incident. So plus,
but she remembered the first night episode in Dover at trial.
When she got to trial.
And
That's
that
right.
was how many months after she had told the district attorney's office that she didn't remember it? How long a period of time was that between you were told?
Well, let me see. It was it was in February or March of 2008 where she was interviewed in Minnesota and said she did not remember it. And then in and then in the trial was in the fall of 2009. she told the police that she did remember it. Excuse me.
Vice versa.
I'm confused. You're asking me about which one now?
I'm asking you about, well, the first night in Dover, when she tells the
All right.
she tells the
I'm
investigators
sorry.
in February.
She did
that
tell them about that.
Then she
Then she
you're
told them she
notified.
didn't remember it in the fall, just in
And was
the
that right before trial, or?
Well, it was a few months. It was I believe, in November.
Yeah,
It
so
was either October or November.
And trial was what, January, February?
Trial was in January.
All right, and so she did remember it at trial.
That's right.
Okay.
Right.
Can I ask you, if you leave to one side Dr. Brown's testimony, and whether or not it was an error to exclude his testimony, what could you have done without his testimony? If you had any or all of the information that you're complaining you weren't allowed to get in, the information about the one or both prior child rape.
Well, I think it was
background information. I mean, where is forget the ground of the statute as a reason for excluding it. Let's just talk about relevance and materiality. If you didn't have the ability to call Dr. Brown, what could you have done with that evidence?
Well, I think that it was relevant and admissible even without Dr. Brown. I think that one doesn't need an expert to establish that all these traumatic events and the fact that her birth mother told her that she was being given up for adoption because her uncles were child molesters. I don't think you need an expert to tell you that this might have some influence over her memory. And all this was in the most intense period of her life, that this might influence her memory, her motives, and her beliefs. This is a case that was...
And that is, I guess what I'm trying to get at is, does that just get you to the point of that the child was just so damaged that she was incapable of telling the truth about anything?
No, not at all. What we say happened is that, our theory here was that when she reported this in February, in the context of this discussion of sexual abuse, what she had was some sort of a flashback or a vision or an image of something that happened to her before. And it was by an uncle.
And you don't need an expert to establish that?
I don't think so. We're the defendant. We're entitled to argue a theory which I think, under all the facts, is really quite plausible. After all, in a case which is about sexual abuse by an uncle, how could the fact that here she was experienced an ever-present threat of abuse by uncles, a fear of abuse by uncles, in the most fraught and indelible period of her life, while she's about to move from one family to another, how could that not be relevant in the Lampron sense of making something more probable and making the fact that I referred to, that she might have first imaged this, had a vision, a flashback back to all this time when she first reported this. It is more it makes a fact either more probable or less probable within the meaning of Lampron.
Counsel, you're suggesting that no expert testimony is necessary to make the connection to all those, I think the research that's cited, that you can have and essentially have a memory and think it actually is happening at a different time, in a different circumstance, so that it's sort of...
Well, let's put.
You
I'm being asked to put aside the expert testimony, and if I put aside the expert testimony, I think it is entirely plausible to the jury to think, well, this is something that came into her mind at the moment in which where they're discussing sexual abuse, and she says, I was abused too. By whom? By an uncle. Now she's pressed to say, what uncle? This uncle or these uncles that abused her before, she has no clear memory of who they are, and she has, and now we think begins a process of fabrication, of a defensive behavior. She becomes committed to her story, and now she fabricates, whether consciously or, Dr. Brown would say, possibly unconsciously, and that's what leads us to the detailed testimony that we get to at trial.
So you're essentially saying you could do it in either one of two ways, either with the science or with
That's
common
right.
sense.
That's right. And of course, Judge Sanders said we need the science, so we offered the science, and he said, yes, her history and her memory gaps are consistent with the phenomenon of dissociation, but she said, well, it's not going to be admissible because he can't make a diagnosis. Well, he says, I can't make one because I haven't examined her, I couldn't properly do it, I couldn't ethically do it, but it's consistent. In fact, I even think it's probable that she has disassociation. And disassociation can account for memory gaps, a vague memory, flashbacks, all of this that specifically can explain what I think a layperson in a very common sense manner can basically understand.
If I could focus you back on the word fabrication, are you saying that the fabrication was one in which, as she testified, she recognized that it had not happened, or is there an alternative argument that she believed it, and because of problems of source memory or something else had refashioned her memory to redefine what occurred?
It could be either one or the other. She could realize that it wasn't so, and she's now defending her story, and she's committed to her story, and it could be on a conscious level. Or Dr. Brown explains in this concept of factitiousness, which is where people, crying for attention, do sometimes do this on an unconscious level, and they actually come to believe these stories that they have.
Going back to the question of Justice Lang, it seems that with regard to the unconscious level, you wouldn't need the Dr. Brown testimony to articulate that to a jury.
Well, I think I probably actually, we have Dr. Brown, so it to some extent it's beside the point. But I do think that people argue all the time that somebody has told a story and that's actually not true, but they have come to believe, and I think that really does happen, and everybody knows that it happens.
Are we to review all of the errors that you claim on an abuse of discretion standard?
Well, actually not, because I think evidence is either relevant or it's not, and this evidence was relevant, and it goes directly to the most important component of our defense, which is the answer to the Commonwealth's almost its sole argument in favor of the credibility of this witness, which is she had no motive to lie. And we are deprived of our entire answer to that question. And I don't see how it could possibly, if there's relevant evidence that pertains to the answer to that question, I don't think it can be a discretionary matter as to whether that's included or not. There is also the issue of the final jury instruction, in which the judge did let in one little piece of this, which she said as a matter of that she spoke and testified inconsistently. In her first interview, she denied any prior abuse. At the trial, she testified, yes, I had been abused before. The judge says that can come in, but not for its truth, and limits it to credibility. At that point, I object, and I say, Judge, what about memory? She says, yes, memory too. She gives an instruction, and I say, Judge, you did not adequately instruct that this inconsistently can go to the witness's memory. And she says, I didn't mean to limit it to just whether or not she's telling the truth. Credibility includes all that. Assess credibility, that includes memory. When we get to the end, it turns out that despite the fact that we've been limited to this one little snippet and limited in admissibility, it's apparent that some jurors got the point, and they asked the question, how can we use this evidence about the abuse by an uncle? Are we limited to just deciding whether she told a lie in the interview, or can we consider it on her state of mind, is the way they put it? And the judge says it's significant only if it was an intentional misstatement, and not if it was a lapse of memory. And it says in the colloquy, this is precisely what she intends to tell the jury. And so basically what little bit that we had was eliminated from the case. She goes on to say, there is no evidence in this case, no evidence in the case, she tells the jury, that ties the events of 10 or 12 years ago to the events of 2007. So this is certainly not discretionary. She's telling the jury how to reason. She's telling them certain inferences about her memory that you are not allowed to make in this case.
Mr. Stern, thank you very much. Any other questions from the panel? Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Tracy Cusick for the Commonwealth. Your Honors, in this case, the trial judge properly exercised her discretion when she ruled that the sexual assault victim's early childhood experiences before she was adopted at 7 years old and proposed expert testimony about a mental condition the victim did not have would not be admitted at this trial. Your Honors, in this case, the incident before...
Well, of course, we don't know she didn't have that condition.
There's no evidence to suggest that she did.
Well, the voir dire of the doctor suggests that there was a great deal of information contained in records that was completely consistent with that.
Your Honor, the information in those records, first, those records where there's about a 9-year gap between those records being created and the events at trial. But, Your Honor, in those records, which are social service records...
And medical records. Weren't there some medical records?
I don't believe so, Your Honor. The records of the social service records of the adoption circumstances.
I thought that he had before him a wide array of documents.
There were documents...
Including the testimony in deposition form of her biological mother.
Yes.
Including Minnesota-related records, police records,
yes.
A whole range of records that Dr. Brown had in front of him and on which he, in one way or another, relied as providing examples of things consistent with various aspects of the syndrome that he suggested would explain those behaviors. So I guess where I'm just starting out, you're saying the judge concluded that there was no evidence presently of the 15-year-old or then 18-year-old Molly displaying those that condition. But it's not, I think, that he said that there was no evidence of that.
Your Honor, I do believe we can go further back, though, in looking at those records which are before the court, before this court. Much of what Dr. Brown relied upon were reports of things the birth mother reported, and later on we have the deposition of the birth mother, which certainly suggests a lack of competency. The judge never made a formal finding, but...
No, she referred to her as the crazy woman.
Also in that, the birth mother she was unable to explain what telling the truth meant. One of the persons she referred to having seen somebody's death certificate and having been made aware that that person was dead, that person was in fact alive. Another thing that she represented in the deposition was the number of her children, their parentage, which is quite different or somewhat...
Had she testified, all those things could have been brought out on cross-examination.
Certainly, Your Honor, but I suggest she wouldn't have been competent to testify, but even if she had been, her testimony wouldn't have been admissible based on hearsay and also based on relevance concerns. The bathtub incident, again, the birth mother reports that the victim and potentially her sister reported that the victim was assaulted in a bathtub. The victim didn't report that. The only report of that is the birth mother's statement that that happened. And reading through those social service records, certainly it seems the birth mother's life is quite chaotic at that time.
Well, but doesn't Dr. Brown suggest that as part of the array of relevant information, one looks to the mother and the relationship between the mother and the child as, in fact, forming the problem, if one exists, and that the mother's own behaviors are pertinent to establishing the condition.
Your Honor, one of the things Dr. Brown relies upon is a report of the mother's interaction with another child of hers, not the victim in this case, but another child, and notes that is significant. And reading through those social service records, apparently that child has a different father, and there is a report of the birth mother having different feelings towards that child. Again, how Dr. Brown can rely upon the birth mother's interaction with another child to then form an opinion.
He relies on her interaction with this child, with Molly, as well. In a number
He
of
does in
respects.
some respects, but one of his major things is he refers to a report of, I believe, the birth mother was playing a game or something like that, not interacting with the child, and that's not the victim in this case, that's a different child. So certainly, and he's relying on those reports, which are observations of people made of the birth mother, of her children, in the context of parental right termination or relinquishment, or however they were going to proceed, depending on what time frame one looks at those. So certainly, he did obtain those records of the victim, of the circumstances surrounding her adoption. But even prior to obtaining those records, in support of his motion to obtain those records, the defendant claimed these records would show that she dissociated and she had these memory problems. Suggests the records didn't bear that out. The records simply show that there was the circumstances of the birth family and what happened when the parental rights were relinquished or terminated. It's unclear exactly how it happened. And then she went to live with the family that adopted her.
So what is the guidance that you give? If the defense can't offer it unless it can show that she suffers from that disorder, and the psychiatrist says one can't diagnose that unless one interviews her, does that mean that the court then should be permitting the interview of these victims to ascertain whether or not they suffer from these disorders?
No, Your Honor, it does not mean that.
Okay, so that means then that this evidence can never pragmatically come in because they can never establish what you say they must establish to get it admitted.
Your Honor, if this evidence were relevant to the issue before the jury, then it would be admissible, but in this case it was not.
Okay, but certainly do you concede that if she did have this dissociative disorder, that would be relevant in terms of articulating an alternative reason for her making the allegation?
Yeah, I agree, Your Honor, but I think that gives us another question of any ailment a person could potentially have. If there's no evidence that they have that ailment, it would seem that would be introduced.
But that's, I guess, the key issue. You say there's no evidence. I mean, the doctor, I gather, said she has the risk factors.
Yes, he does identify some risk factors.
And is that not enough to say that this person has the risk factors?
Well, Your Honor, by way of an example, if an older person forgets where their keys are, I mean, they're older, that's a risk factor for Alzheimer's. Would we then say that one could introduce evidence of Alzheimer's if that person's memory, if the defendant was challenging that person's memory? I don't think it's enough to just say there's risk
that's an
factors.
interesting question, not before us, as to whether somebody could testify to the consequences of dementia and the loss of source memory as one gets older.
But I believe the analysis would be the same. If there wasn't any evidence that the person actually had it just because the ailment exists, wouldn't by itself make it admissible.
But I guess the question is then, what quantum of evidence is sufficient then? If I gather you would say it's more than risk factors.
Most definitely more than mere risk factors.
So where is that level by which it's more than risk factors but sufficient? What would make it sufficient to get that evidence in?
Your Honor, it's hard to answer that question in the context of this case, where all we do have are the risk factors. The other thing we have in this case is evidence of the victim functioning well, succeeding in high school, active in school activities.
And of having significant memory lapses, at least, in connection with certain events, which she can remember, and then she can't, and then she can, and then she can't. So
Honor,
it seems, well, at least the argument could be made that these things have happened, including that she couldn't remember whether or not there was something that happened on the first night in Dover, after she had disclosed that something had happened that night. And then the district attorney, of course, had to tell defense counsel that she could no longer remember that. And then at trial, she did remember that. And then there was the whole business about the so-called bed rape by the uncle when she was young, which she could remember when she was, I think, in the 8th grade, and then she couldn't remember it, and then she did remember it. So whatever you make of all of that, that is certainly also something that is evidence on which an expert could comment.
Your Honor, I believe the characterization of that evidence is memory gaps or memory problems. So just another characterization would be people, their recollection is refreshed quite frequently in a courtroom. Someone says, I don't remember that. Their recollection is refreshed. I suggest that this
It's not just that something can be characterized another way. The question is whether the defendant has the right to be able to characterize it in an alternative way.
The defendant's characterization of the evidence here, certainly the jury heard the prior inconsistent statement about the bed rape, where she had initially said nothing like that had happened before, and then she said it had. So certainly the fact that it was not front and center of her daily thoughts, and she didn't think about it a lot, and that's what she said. She said with respect to the bed rape, she had been thinking about her birth family, and then she recalled that incident. So certainly there might have been something about thinking about her family that made her think about that incident, but that doesn't equate to a memory problem or some sort of significant deficit of memory where someone just says, I didn't think about it and then I did.
I mean, not that many people have a history of rape by uncles. Doesn't that separate this case from the usual case where there's a substantial prior history not only of abuse by an uncle at an early age, but also the mother at least purportedly telling the child that I'm giving you up for adoption because I'm afraid of further rapes by uncles?
No, Your Honor. In this case, there's one incident, the bed rape, one rape, prior instance of rape by an uncle. It's not that unusual for someone to have a prior instance of abuse in their life and for it to be by a family member. And again, the birth mother is reporting these other incidents. The birth mother is reporting why she relinquished the victim for adoption. Certainly that's her recollection of events after the fact, and she may have her own reasons for stating that, but review of the social service records indicates that, in fact, the birth mother was quite friendly with the birth father's family, and they were being considered as a placement. So her later recollection of telling the victim that is not necessarily, it doesn't really add much to this.
Well, I mean, apart from what the real reasons were, would it not be relevant if the mother told a very young child that that's why I'm doing this?
Your Honor, I suggest there's no credible evidence that the mother actually told her that. The only report of that is the mother saying it sometime after the fact. And again, there are the problems of that birth mother's, at least her deposition, being factually flawed in terms of not knowing that the birth father was in fact alive and claiming to have seen his death certificate and also not even being able to identify her own children. So certainly I would suggest that that's not reliable evidence.
But the judge never ruled on that.
The judge ruled that the birth mother would not be permitted to testify.
But
So
not on competence grounds.
It seemed she was considering that, but said she didn't need to go there because the birth mother was, her testimony would not be relevant and it would be hearsay.
Thank you, counsel.
Thank you, Your Honor.